all, before I even get started, we don't have a sign-in sheet, but they didn't have a sign-in sheet out front, but I want to pass one around if you don't mind. Could you fill it all out? Last time I did this, I started in the back row, and only the back row filled it out. So if you could clean up. So great, thank you so much. All right. Got a microphone and everything tonight. I guess I'm not loud enough for you guys. But thanks everybody for coming. Who hasn't been to one of my classes before? Only you guys. And you're in the front. Yay. Okay, wonderful. Well, I'm so glad to see everybody else here tonight. I know you've come to my classes over the last several years, and we try to do things, we try to bring in new classes when we can, and get topics in here that are critical to the success of your association. And what I've decided to do in this current class is go over some of the things that come to my attention um, over the last 14 years of my practice. These are the things that come up all the time that I have clients calling me and saying, what do I do in this situation? So you're going to see 15 random things. We're going to talk about 15 random things that I see happen to associations, and I hear happen to associations and boards of directors. And if they don't know how to respond to these things, then they get themselves into trouble, they get the association into trouble. It's all about exposure to liability. So as we go through the class, this is a pretty well-sized class, but it is a two hours worth of material, but enough. I mean, I can take questions as we go through. As you know, those of you have been to my class before, I take questions throughout the class, and I'm happy to answer your questions. I'm also happy to come at the end of or stay at the end of the class and answer additional questions then as well. Okay? Okay. Well, let's go ahead and get started then. And so, first of all, how many people here are board members? Okay, okay. And any architectural review committee members? Because sometimes I'll bring up examples for ARC members as well. Are you both on the ARC and the board? Or just, okay, or is the board serving as the ARC?
Double jeopardy.
Double jeopardy. That's what usually happens is nobody is willing to serve on the ARC. And so the board, unfortunately, there's apathy in the community, and so the board ends up serving all these other roles as well, which the board can certainly do, but it would be better to have homeowners that were actually concerned and willing to serve and take some volunteer time to help with the association. Is everything coming out okay? Okay, all right. Okay, so let's go ahead and start. What I start every single class discussing is the director's obligation, the fiduciary duty that the director has for his or her association. So I'm going to ask, I know a lot of you have been to my classes before, so I'm going to ask you, I try to make this interactive too, what is a fiduciary duty? And I didn't write it in there because I wanted you to tell me. So who's been on the board for a while? Yeah.
It's your responsibility to act in the interest of the HOA.
So act in the interest of the association, certainly, just in any manner, or, I mean, anything else? Anybody else want to throw in?
Particularly financial.
Particularly financial. Financial issues are always scrutinized, as we know. Anything else about being a fiduciary? What does it mean? So a fiduciary means that you are in a position of trust. So not only were you elected to come onto the board to serve for your board, you probably have your own agenda. Nothing's wrong with that. You came on the board for a certain reason. Why did you get on the board? Those of you who've been on the board for less than a year, why did you get on the board? You tell me.
One, nobody else offered, and two,
Nobody else offered.
I wanted to know what was going on.
Okay, I heard somebody say I didn't step back when they called. So nobody else offered, right? Nobody really wants to serve on the board, which is a common problem. And you want to learn more. No? Okay, what else?
If I am invested.
Absolutely, yes.
Upgrade an aging community.
Upgrade an aging community. So you have certain things that need to be replaced and repaired, and it's time to upgrade that. Okay, so you had a specific interest in helping with that project, right? What else? Yes.
To get the board to enforce on our rules and regulations.
So maybe a prior board was not enforcing uniformly or even enforcing at all.
Exactly.
That happens quite a bit. Anybody else have that problem? Maybe they got on the board because of that? Okay, so that is a common problem where maybe prior boards, not for any bad intentions, but for whatever reason they're not enforcing as they should, and so you step on and you then try to enforce. We're actually going to address that. That's one of my issues. Okay, so it's a position of trust, like doctor-patient, like attorney-client. When you took that position on, you took on the obligation to act in the best interest of the association. And I always start the class with this slide, regardless of what class or topic I'm teaching, because this duty on this first slide is what the court will look at whenever your decisions are challenged. So let's say you make a decision. Has anyone here made a decision that was challenged by the membership? Come on, don't be shy. I'm sure, right? No? None? Wow, you guys are lucky. You guys are lucky because oftentimes there's a challenge, particularly if there's a lot of money being spent. Everybody wants to know, make sure that their money is being spent correctly. Or it's a controversial issue. Maybe it's an amendment to prohibit all smoking. Or maybe it's something about leasing restrictions. But whatever it is, it's often an unpopular decision and this gets challenged. Now if for the Architectural Review Committee members, let's say you deny a particular improvement and somebody challenges that denial. So if you are challenged, whether you're a board of director member or an ARC member or somebody else that's acting on behalf of the association, when you get challenged, and unfortunately if they do take you to court over this, because unfortunately there's lawsuits that are filed against board members individually now, not just the association, but they're actually looking, sometimes it's not even the entire board, it's just one person on the board that they're trying to make an example of. But if you get sued, unfortunately, then what the court will look at is, did you make your decision in good faith, in the best interest of the association, and prudently? Those three standards, that's what they're going to look at. So quickly I'm going to go through each one. In good faith means not in bad faith. Don't act maliciously. Don't act with ill will. Sounds easy, but there could be these situations where you are trying to do your best, but unfortunately the person that's challenging your decision is also somebody that's challenged every single other decision for the last 10 years. So you're sort of have this preconceived notion about this particular person that they are just only there to provide negative comments. Then all of a sudden you're treating them differently. You're making them jump through additional hoops. You are giving others leeway, whereas this person you're making them follow every single requirement. And if that is shown in your paper trail, if he or she can show that you're treating him or her differently, then that's going to be seen as bad faith. You're acting with ill will against this person. Regardless of your intent, it might be seen that way through the actions. So in good faith is one of them. In the best interest of the association means not in your best interests. I know that you're all homeowners and I know that you're on the board to serve the purposes of the association, but oftentimes those decisions you make are difficult. And oftentimes they might not be in line with your own individual interests. I had a situation where an association wanted to levy a special assessment, or a board did, because they really needed the money to fund a particular repair project. And 2 of the 3 board members voted against it, and it turned out they voted against it because they knew that they couldn't pay for it themselves, that special assessment. That was uncovered from a lot of discussion with the board. And I said, you are not serving the interests of the association, you're serving your own interests. So if you don't feel like you can make these difficult decisions, you need to get off the board. The other situation where I sometimes see this is if you are making your decision in the best interest of the nicest person, the person that comes along and is very, very supportive of all your decisions, and then when they come up, all of a sudden you're willing to do whatever they want because they're so nice and they're so supportive and so involved. That could get you into trouble if you're treating the neighborhood naysayer differently. So you're not acting in the best interest of this nice person. You have to look at the association as a whole. And so this one example I always use is the wind chime example, where a very nice lady came to every single board meeting and she was very involved and very supportive of all the decisions, and she was a registered nurse and she could not sleep during the day because she worked at night. She couldn't sleep during the day because of these wind chimes that were next door. and she lived in a patio home community. Everybody had these houses that are very close together, and so she came and she said, you know, everything's great, but I wish you would do something about the wind chimes. And so the board finally said, okay, we want to do something nice for this lady, so they adopted a rule against wind chimes. So they did this, and for those of you who've heard this, you know what happens next, right? The largest attendance ever at the next annual meeting. Why do you think that is?
They want to keep their wind chimes?
Yeah, do you know how many want to keep their wind chimes?
Everybody but the woman?
So it's almost, I'm going to say maybe 30 or 40% of the community had wind chimes. So this board was trying to do something nice for this involved community member. But in doing so, they didn't do their due diligence. They didn't go around and see if this is an actual rule that affects and benefits the community-wide interests versus the one. The other time I see this as an issue is if boards cave to the loudest, to the small section of homeowners that might have an issue that is actually for the best interest of the association, but sometimes it's not. But they continue and they continue, and they're very dynamic, and the board just kind of caves, even though it's not in the best interest of the association. So definitely take off your homeowner hat, forget who's requesting that issue to be resolved, and put in that place just the generic person that's making the request, and try to solve it that way. And then finally, in solving and in addressing that issue, act prudently. What that means is ask a lot of questions, particularly if it is a decision that involves a lot of money. Those are the decisions that get scrutinized the most. And it doesn't matter how much you do in your board meeting to make an informed decision. How many people here have homeowners attend their board meetings on a regular basis? A few of you. Okay, well, that's good. That's good, because most of the time, nobody shows up. Nobody comes to the board meetings. Nobody comes to the annual meetings. Apathy is a big problem within HOAs today. So even though you are trying to act in the best interest of the association by making an informed decision, and you don't want to act in a vacuum, you definitely want to try to get people to come to these meetings, but if they don't, then you communicate. And you try to give as much information as possible so that they know that you didn't make a decision that was just out of the blue, which is sometimes a perception. How did you make this decision? How did you come to decide to levy a $100,000 special assessment against the community? Where did that come from? So, in good faith, in the best interest of the association, and prudently, if you make the decision based on that standard and you paper trail it, you try as hard as you can to show that you made an informed decision in good faith, then even if you were sued individually, you will not be held liable. That's what's called the business judgment rule. You're protected as volunteer board members in your decisions. Courts do not want to second guess a board that acts according to this standard. They will protect you as long as you show you made your decision according to the standard. Anybody here get paid for serving on the board? I get a couple chuckles sometimes, but anyone? No? No salary drawn for serving on the board? No. No credit for your dues for serving on the board? It's the same thing. It's going to be seen as compensation. No. Okay? Okay. Well, you should know this, because if you do get paid in some way, even if it's a small amount, the protection under the business judgment rule might not apply. Then all of a sudden, you are being paid for your decisions. So just realize that if you're thinking of doing that, think twice and don't pay yourself. Even though the law allows you to do it, your governing documents probably don't allow you to do this. There's probably a very clear statement that says no compensation for directors, but in case you were thinking of amending that out, think twice about it, because you will lose your protection. Okay, let's go ahead and get started. Our first one. Yes, sir?
Does that previous slide also apply to committees, such as the Architectural Review Committee?
It does. It does. So the volunteers that are acting and they have decision-making authority, like the Architectural Control Committee, are protected by the same standard. But the only committee really that has decision-making control is probably the Architectural Review Committee. How many others use other committees? Does anybody else? Okay, well, like,
Maintenance and budget.
so you have a budget committee, but the budget committee brings the information to the board to make the decision?
Recommends a budget to the board.
So ultimately, the board makes a decision. Usually, the only committee that's standalone that has its own authority to make decisions is the Architectural Review Committee. All other committees bring that information to the board to make a decision, and so they are protected. Okay, let's get started with enforcement. Who was at my last class last month? Okay, so remember how I was so sick? I'm still there. I'm still coughing. And I'm like, oh, I still have my cough drops there. Not as bad, but I'm still there. Anyway, you'd hate this. This is terrible. It's like a month later. Sorry for the hacking, and now I'm hacking into a microphone. But all right, so uniform enforcement headaches. Number one, and none of this is in any order. Okay, this is just random stuff that I came up with. So don't think if it's number one, this is the most important issue. But enforcement and non-uniform enforcement is a big problem with associations. And what I mean by that is arbitrary enforcement, which is you get the claim from a particular homeowner that you are picking on me. You are not enforcing against anyone else. This is one of the main claims against associations today, that they are enforcing only against certain people and not against others. Now, is that usually happening? Probably not. Hopefully not. But they don't see it. They don't know that other letters aren't going out to other people who are violating. They don't know where the status is with respect to other enforcement violations. And the reason why is you're not allowed to say anything about it. You're not allowed to provide that record or that documentation to the homeowners. Several years ago, you were able to provide that information. Several years ago, the law allowed you to give enforcement logs to homeowners at request. But one of the problems we're going to talk about tonight is just the inspection of records issue. The law has changed. So now there's no ability of somebody to come into the management company's office and say, I want to see all the enforcements that are occurring. So all you have to do is respond and say, we are taking enforcement against other homeowners as well. But no, don't give them any specific details. Now, if you're not, ask yourself why you're not enforcing on a uniform basis. Is there any reason why, for example, a homeowner comes to you and says, let's say sheds are not allowed, and a homeowner comes to you and says, there's a shed on so-and-so address that was installed without approval. So you would go and enforce that. Is there a reason why you wouldn't enforce maybe another shed somewhere around the neighborhood? Can you guys give me a reason why? Yes, ma'am.
It had been there for a long time.
Maybe it'd been there for a long time. We'll talk about that.
Location.
What could be another? Location. Okay.
Oh, we gave approval for a homeowner on a corner lot
Uh-huh.
facing the railroad tracks.
Okay.
The ability to increase the height of their fence by one tier because they were putting in a pool, and the code required the external fence to be a certain height.
So there were circumstances that were isolated to this particular situation, right? Where you might give approval where approval wouldn't normally, a variance, right? That's another reason too. Any other reasons? So one of the reasons I sometimes see often is we only enforce by complaint. How many of you have management companies? Okay, so some management companies are hired to actually go through and inspect. But they're not going to see every single violation. I mean, some of the things are hidden. Some management companies aren't hired to do that. And so the board says, we want to just enforce by complaint. It's okay to do that. It's okay to have that level of aggressiveness with respect to enforcement. We will enforce by complaint only. So there are many reasons why you might not be enforcing on a uniform basis, or people think you aren't. And it's either perception or there's a good reason why. And we'll talk about some of those reasons why here in a second. So the second thing is preferential treatment. Remember I told you that, you know, if you are not enforcing against a board member. Now, board decisions are scrutinized all the time. And if it looks, smells, sounds like you are giving any kind of preferential treatment against the board member, then you should be very, very vocal and clearly show that you're not. The problem I sometimes see is boards do give preferential treatment by failing to enforce against a clear violation of another director, because it's an uncomfortable situation, because nobody wants to call them on it, because, well, this is the board member that gets everything done, we don't want to ruffle any feathers. Well, that's even worse. If you're failing to enforce against the rest of the community, that's bad enough, but if you're failing to enforce against a board member with a clear violation, that's going to expose the association to liability. Again, these are one of the strongest claims against homeowners, or against associations. When a homeowner brings a lawsuit against the association, or the vice versa, let's say the association is suing somebody for failure to get architectural approval for this shed. And if they turn around and they show 10 other violations that are not being enforced, and you don't have any files to back up that they are being enforced, you're probably going to lose on your action against that homeowner, because you're not treating everybody the same. It doesn't have to be the same type of violation, it just has to be the lack of enforcement. Okay? And then finally, setting precedence claims. That kind of goes to, I think you're the one that said prior boards were not enforcing. So the other situation is not just prior boards not enforcing, but also the developer not enforcing. Is there anyone here that's in a transition from developer control to owner control? Okay, no? So what we often see is the developer will fail to enforce, nothing against developers, but they have their own interests, they're trying to sell the community, and they might grant a bunch of variances for particular things that are clearly against the governing documents. Or we have a prior board that is lax in enforcement, or what have you. For whatever reason, they're not good at enforcing. Anybody, now you're in that situation, anybody else in that situation? Okay, what do you do? What have you done to try to break free from that? Anybody have any? Yes?
President resigned, and
Okay.
we hired a management company.
Okay, so the president resigned, and you're not the president, right? Okay, so president resigned, you hire a management company. The management companies are going to be pretty uniform. They have their own, they're doing their contract. But if you don't have a management company, then what you want to do as a board is you want to break free from that prior board and that prior inaction. You want to communicate that you're first of all, you're not going to retroactively enforce against some of the things that have occurred, particularly construction violations, which we'll talk about in a second. But you are going to break free and say, we as the new board have a duty to enforce the covenants. We are going to enforce them moving forward. We're going to give you a reasonable period of time to come into compliance with whatever those violations are, and then we're going to start enforcing. We'll talk about the specific problems with that in a second, but you definitely need to break free. But if somebody says, you cannot require me to submit an ARC approval request because you didn't require that guy, that is not precedence. Precedence is a court ruling saying you shall not apply a particular violation. You shall not enforce it. Failure to enforce against one person, two people, three people is not a waiver of your right to enforce moving forward. Be clear about that. We're going to talk about when it might be, but in general it's not. There's probably language, I'd say in 90% of the declarations, covenants, there's language that says failure to enforce in one instance does not mean you have waived the right to enforce moving forward. For all the reasons we just said. I mean, somebody said maybe there's a variance that's required, or whatever. Yeah.
Could you repeat that again? What is precedence?
Precedence. Well, precedence is not. It's not set. I'm going to say, by failing to enforce in one case, you're not setting precedence for then waiving the right to enforce that violation moving forward. Okay. Yes.
Well, for instance, in our neighborhood, we have a person who has a trailer parked in their backyard. Well, in the covenants it says no. And my dad's been doing it for 3 years. The developer made the fence for him to do that. So, and
I'm going to talk about, I'll use your example in a second.
Okay.
I'll use your example in a second, because that's coming up the next slide. Okay? All right, so just just know that in most circumstances, you're not setting precedents by failing to enforce in one particular situation. But that's another claim, number 2. Failure to enforce. Not just non-uniform enforcement, but failing to actually enforce a clear covenant. Does anybody have something in their rules, regs, or covenants that they don't enforce? Or that you're willing to say that, yes, what do you have in yours?
Everything.
Everything, okay. All right.
Our covenants were made before we were part of the city.
Okay.
And they're 30 some odd years.
Okay.
There's hundreds of things in there that says that no one's supposed to do, but no one knows,
No one
no
is-
one cares.
Okay, all right. Well, so we'll take your situation in a second, because we're probably going to talk about either amending or doing something there. But in general, a claim against a board for failure to enforce a clear covenant is just as strong as non-uniform enforcement. So let's say you had a restriction that said no dogs. If it's clear and somebody moves into the community and there's a bunch of dogs, there might be some claim against the association for failure to enforce because it's very clear. But the next bullet point, abandonment. If you have failed to enforce to such an extent, and I don't know if that's your situation or not, but if you have failed to enforce for such an extent in such a long period of time and there are so many violations, then the courts might actually say, you have no right to enforce this moving forward because you have abandoned the right to enforce it. But it's an extremely high threshold. This is I don't remember the name of the case, but this is an actual case in Colorado where it was a shed installation issue, and there was 100 homes, and almost 50% of the homes had sheds on them, and the court still said they had not abandoned the right to enforce it moving forward. See how high that threshold is? It has to be pretty darn high. And the reason why, and this is the current law, is if a reasonable person can drive throughout the community and think sheds are allowed, you've probably abandoned the right to enforce the shed violation. The reason why it didn't apply in this particular community is because all the sheds were in one area. They were all concentrated in one area because one person saw the guy across the street had a shed, so they put up a shed. And it was all concentrated, not throughout. So the court found that throughout the rest of the community, those that didn't have sheds, they could not put sheds up, even though almost half of the community did have sheds. Which is, the courts want to defer and they want to allow you to enforce your covenants. They're just looking at a fairness issue, which is they're not going to allow you to enforce it retroactively against the people that already have those sheds up. They're looking at you moving forward with enforcement. But in this gentleman's case up there, if you have so many things that you're not enforcing, or for whatever reason, maybe you don't think that they work for the community anymore. I have seen many associations that have provisions that really, everybody wants dogs now, and they have something that says no dogs, or maybe people want chickens, or maybe people want goats, whatever the trend is, pot-bellied pigs. Whatever that is, it's not reflective of today's community, which is why boards are failing to enforce them. So what should you do if you have something in your documents that does not reflect the community's intent today? Change them, right? Change them. If you don't change them, you're going to be in between a rock and a hard place. You are going to be potentially sued for failure to enforce a clear restriction. You don't want to be in that situation. If it's if it's to such an extent that people aren't enforcing across the board, you want to consider amending it out. Okay? Yes, sir.
How does it bleed over from one section to the other? Like, say you had a restriction like no dogs, and you didn't enforce the no dogs. Is that an abandonment of all enforcement, or is it only an abandonment of the dog enforcement? Like, say you had a parking restriction.
It's only okay. That's a good question. The question was, okay, so you have failed to enforce the dog violation. Is that an abandonment of the right to enforce in general, right? No. It would just be an abandonment, potentially, of the right to enforce the dog situation, the dog violation.
One follow-up to that.
Yeah.
So if you had that, say, in a parking section,
yes,
and you failed to enforce it for RVs,
mm-hmm.
would you still have the right to enforce it for boats? Or is that?
Potentially, yeah, I would think so, yeah.
Even though it's all in the same section?
Yeah, because a section could have several different types of violations, and I would be arguing you only abandon the right to enforce one. Yes,
We have a rule that says you can only have 2 pets.
okay,
And somebody in the community has pointed out to us that, you know, they've never heard of us. I mean, how would we know how many pets people have?
okay.
So they were suggesting
Well,
that
that's
we change it to have a reasonable number of pets.
Okay.
And then, you know, I know somebody who hoards pets.
No.
Not in our neighborhood, but
Okay.
they have 21
The
pets.
cat lady,
Yeah,
right?
21
Yeah.
pets in their house, so.
21, is that what you said?
In the house, so,
Well, I
I'm
mean,
wondering now if,
I actually, I mean, I'm a fan of being a little bit vague in the covenant, so you can be, because let's say you have something that's very clear in the covenants that says no more than 2 pets, period. 10 years from now, or 5 years from now, you might want to change that to no more than 3 pets, because that's reflective of the community. And then another 5 years later, you might want to change that to 4 pets. But if you do that, if you have the 2 in your covenants, then every time you change it to a different number, you're going to have to amend the covenants. What does it take to amend the covenants? Those of you who've been in a lot, anywhere from 51 to 67% of the entire community has to approve a change, which is why I'm more of a fan of having deliberately vague provisions in certain circumstances, such as use restrictions, pets, a reasonable number of household pets. That allows you to give a list of what are considered household pets today that you can then change in 10 years without having to go through the entire process again. Okay, yes?
How do you enforce vague covenants? Because there's always an argument about it.
There's always an argument. That's a good question, because first of all, if it becomes an argument constantly, the board has every right to adopt a reasonable interpretation of that covenant. So let's say you have, what is a commercial vehicle?
Yes,
Can anybody tell me what a commercial, is that a Mary Kay vehicle with a little sticker? Or is it a cement truck or something like that, right? If this comes up quite a bit, then I'd say that the board should adopt a resolution clarifying what that term means. And a court will defer to that as long as it's a reasonable interpretation. And once you have that resolution formalized, it's a document saying, this is our interpretation of this covenant, it will stand. Now the problem with that is any future board that chooses to could say, we don't agree with that interpretation, we are going to overturn it. So if it really is a big issue, then amend. If you amend, it'll stick, because only homeowners can approve that amendment and any change to it. Yes, sir?
What about going the route of rules and regulations versus?
Rules and regulations, same thing as a resolution. You can use rules and regulations to clarify and supplement restrictions in your covenants as long as they're not contrary to the covenants themselves. However, any future board can overturn rules and regulations. So I'm always saying, what are the most important things in your community? And if you want them to stay so that no future board can overturn them, amend your covenants, get the homeowners to approve it, go through that process, and you know it's going to stay. So whatever the interpretation of commercial vehicle is in the future, if you amend it in the covenants, it's going to stick to that particular interpretation. Okay? All right, let's move forward. Enforcing parking restrictions on public streets. I'm assuming that most of you have public streets within your communities and not private? Okay. You have some have private? That's better. If your streets are private, you have pretty good regulation authority over those streets. You can adopt rules and regs over them. You can adopt parking restrictions. If your streets are public, you should know this, because regardless of the fact that it might say the association can enforce private restrictions, regardless of what's in your covenants. If your covenants say no RVs on the street or no parking on the street, the state of the law right now is split down the middle. Colorado does not have any law right now that says you have the right to enforce private restrictions on public streets. Some courts say, absolutely you have the right. If it's clearly stated in your declaration, yes, you do. People bought into the community knowing that they had to follow these rules. Others say, no, the streets are not within your jurisdiction. They're public. Only the city or the town or the governmental entity can enforce those. So if you have this situation, then know that it's 50-50 shot if you go to court, if somebody actually challenges your enforcement authority. Some of the associations have actually amended the parking restrictions out because they don't want to be in that position. And if they do amend them out, then you're just relying on whatever city ordinances are in place. The one situation that might give you a stronger case that's been successful in a lot of states is under one fact scenario. If your streets were dedicated to the city after your declaration, i.e. your covenants, was recorded against the land, then the city arguably takes subject to your restrictions. So if you're wondering, do we have a stronger case? That's only one element that makes for a stronger case. There's others too, but I always want to start with that. If you're wondering, do we have a stronger case to enforce our private restrictions on public streets, first look at that. And the way you can find out when the streets were dedicated is get a copy of your plat map. All communities were developed with maps that were recorded at the clerk and recorder's office that shows the community. On that map, it'll show if and when the streets were dedicated to the public. It's the same, there'll be dedication language there. So you can look at the recording date of the plat and the recording date of your covenants, and that will give you potentially a stronger case to enforce. Yes, sir.
Have there been court cases that have won on that issue in Colorado?
Yes, but only trial cases, no, and civil county cases, no court of appeal cases.
Oh.
So they're split.
Yeah.
So we've been successful in a number of counties and cities where you had that scenario, where the city was actually dedicated the streets were dedicated after the covenants were recorded. So we make that argument. Okay? All right. Next one, construction violations. Here's where the fence issue, whoever had that fence issue. What the statute says, you have to be more aware of building violations. And by building violations, I mean things like sheds and fences and some kind of construction. If somebody installs something on their property in violation, and it's a construction violation like a shed or something permanent, on their lot without approval, and the declaration requires approval, the statute of limitations for your ability to take action on that violation is 1 year. 1 year from when you knew or reasonably should have known of that violation. So what that means is, let's say again, we'll stick with sheds. If sheds are prohibited and somebody installs a shed, let's do fences because sheds could be non-permanent, so let's do fences. Somebody installs a fence without approval. That fence is up for 1 year. The board sends a bunch of letters back and forth saying, hey, you're in violation. Hey, take the fence down. Hey, submit an ARC approval report form. They ignore it. After that year, you can no longer take them to court to compel removal of that fence. You take action means file a lawsuit, not send letters. Letters will not stop the 1 year statute of limitations. So that's the one thing that you've got to be careful about. The second thing is, it's when you knew or reasonably should have known of the violation. So there was a situation about the fence up, and let's say the shed was inside the backyard of that fenced area, and no one knew about that shed. All of a sudden somebody moves in next door and says, hey, there's a shed there, and that's in violation. And then they submit that complaint to the association. That's when the 1 year starts running for that particular situation because it's not an obvious violation. Nobody alerted the association of that violation until the complaint. Now that's construction violations. You were talking about RVs in the back, or you were.
Somebody trailer.
Trailers.
Right.
So trailers being parked, that's not a construction violation. The fence around it is, so you can't require somebody to take down a fence. But RVs, or any kind of parking violation, is not a construction violation, so it's not subject to the 1 year statute of limitation. You can often argue that it's every day that they continue to park there is a continuing violation against the land. That's one argument. Another one is, counter argument would be, if you are not enforcing against everybody, again, there's other parking violations around, then why would you enforce against this particular person? That brings back the non-uniform enforcement. But just realize, non-construction violations are not subject to the 1-year statute of limitations. You can continue to enforce those. The particular facts of any particular case will either strengthen or weaken the particular case, but bring that to your attorney, okay? Yes?
When does the 1 year start? I'm sorry.
The 1 year starts when you knew or should have known. So when you knew was a clear way of when you would know is if somebody submits a violation and is dated some letter saying this person has a SHEVA. Or maybe the person submits an architectural review submission form and dates it, and you deny it and they install it anyway. From the day that you denied it and they installed it anyway, that's when it starts. The wiggle room is if it's not something that you see, obviously, and you don't know about it until somebody brings it to your attention. Okay, any more on that one? All right, let's move forward. Okay, oh yes, sir.
What about something like a trailer that might come and go? Let's say they didn't store it in their backyard, but they brought it for a few days and then it...
Well, a trailer is not a construction violation. Remember, parking is not a construction violation.
So you can, if it comes again, then it kind of starts over. You know,
Yeah,
you have
it's a, every day that it's a new violation every time they move the trailer and put it back. Let's say there's no parking in the driveways. Every time they move it and then repark it in the driveway, it's a new violation. But what is another situation where you can argue a construction violation? Similar to that, a window-mounted AC unit. I could probably argue as a homeowner that it's not a permanent construction violation because they take it down every winter. And so it's not the same as the permanent types of constructions. So, you know, I mean, it'll depend on the particular improvement. Okay. All right, let's move out of enforcement and go into transparency. Now, you'll see that there are a lot, the legislature has been focusing on HOAs for the last 10 years. There have been a number of laws that have been put into place over the last 10 years that serve to make an association more transparent. So more access to records, more access to meetings, more records that are available, more ways for homeowners to participate in board decisions or board meetings. So let's talk about some of the transparency issues that have come up over the last couple of years. Attendance at board meetings. First of all, are homeowners entitled to attend board meetings?
Yes.
That's always been the law. So what's a board meeting? You tell me what a board meeting is. If a couple of directors get together at Starbucks and talk about an HOA issue, is that a board meeting?
No. I think it
Some
has
say
to be
yes, some
announced.
say no.
It has to be announced.
Well, I'll get to that in a second, but
Only if there's a quorum.
you know, honestly, the statute doesn't even define it. The statute does not define what a board meeting is. But I'd say if there is a quorum of directors getting together, and definitely if you take any kind of action, it looks like a meeting, it smells like a meeting, I mean, that's a meeting. But there's some questionable situations and scenarios that probably fall under work sessions, which I'll talk about. But if it's a board meeting, then you absolutely have to allow homeowners to attend. There's only a couple of scenarios, I'm going to talk about them in a second, that you are entitled to close session to just board members and anyone else you think is necessary for discussion. But somebody said meetings have to be noticed. Do you actually have to send notice to homeowners of board meetings? Or do you? Let me just ask you, do you send notice of your board meetings to homeowners?
No.
Well, some do,
Well,
some don't.
so there's a strange thing that I got into an argument with our property manager about. Because the law says...
Is he or she here?
No.
Okay, good.
It says that if
fight
you can have, as an owner, you can, it's in a section of, you can ask, if you give your email address to the board, you can ask to be contacted if there's going to be a board meeting.
Okay.
But it doesn't quite say if there's going to be a board meeting.
You have to give notice, right? It doesn't quite say that, right?
Well, it says it, but it says...
It actually doesn't.
It's kind of poorly written, actually.
State law, well, no, it was changed. The law was changed. State law does not, even though it's a good idea to be transparent and to let everybody know that there's a board meeting coming up so they can observe the decision-making process and see what's going on and to minimize future disputes, there's no state law that says you shall give notice to the rest of the homeowners within the community for board meetings. For a short time there was, and then they pulled it out of the statute. They expressly pulled out notice of board meetings to homeowners. And I'm not sure, my guess is because if you think about the cost for sending notice, as particularly if they're still going to require it to be by mail, for every monthly board meeting to the entire community, that could be quite costly. But I think that'll probably change in the future. Right now what it says is, to the extent, no notice is required to be provided to homeowners, even though I think it's a good idea to post these and let people come to these meetings. But to the extent that anybody asks you for notice of the board meeting, you're required to provide it to them. To the extent that you have an agenda, you make an agenda for your board meeting, it's required to be available to homeowners. So it's more of a, we're putting the onus on homeowners to request you as a board to notify them of upcoming board meetings, but there's no requirement. The only requirement under Colorado law is for board members to give notice to the other directors for special meetings, not even for regular meetings. What the law says right now is, if you as a board adopt a schedule of regular meetings throughout the community year, so for example, first Thursday of every month is when we're going to meet. That's a schedule, or specific dates. Then you no longer have to give notice to the other directors for those meetings, for those regular meetings. If you are going to have a special meeting outside of that regular schedule, then you are required to give notice to the other directors, not to homeowners. Now, to be transparent and to meet the spirit of the statute, you want to post these. Why do you think people don't? Why do you think board members don't want homeowners to attend meetings? Is it because they're doing something secret?
The time that it takes for arguments.
So maybe the hour meeting turns into a 5-hour meeting, right? Is that usually why? Because I hear this all the time, that we really don't want it. And it's not because you're making any secret decisions, but it's usually because of the disruption. The meetings end much later than they would normally end. I say that's the fault of the board. I say preside over that meeting, run through the agenda, tell the homeowner, you're out of order, you're here to observe, you're not here to comment on every single thing, and drive it yourself. And if they can't, and get it in the minutes if they keep disrupting the meeting. Mr. Smith, we've already told you 3 times, you're out of order, and put it in the minutes, because this is something that you drive. And if they cannot stop interrupting, then you ask them to leave, and you get that in the minutes as well. Yeah.
My understanding was that you did need to give them an opportunity to speak before.
We'll talk about that in a second.
Okay.
So, I want you to come up here and teach with me. No. So, or Ed down there, he can come up and, yeah, I know your name, yeah. So, it's up to you to make for an effective and efficient meeting, okay? And you can't say it's because homeowners are present that your meetings are lasting 5 years or 5 hours. It's because you're not running it smoothly and correctly. And if somebody's presiding over the meeting that does not have the type of personality that can drive it, have somebody else do it, because that's the reason for it. So this lady right here said it's her understanding that under current law, homeowners get to participate in board meetings in some way. In some way.
Mm-hmm.
How is that? Can somebody tell me? That is the law. Go ahead.
Does it have to be on the agenda?
No. Mm-hmm.
Comment on actions before the board takes the final action.
Correct.
Yeah.
So, what the law says now, this is one of the changes over the last couple of years, is prior to the board taking action on something, if homeowners are present, you are required to open it up for discussion and input from the homeowners. So, and this is the intent of this, is that you're not acting in a vacuum, you're getting feedback from those present. But they provide the feedback. They don't vote on the proposed action. Once the feedback is completed, then you as a board can take action. Now, that doesn't mean that if 100 people show up at your board meeting, you have to have everybody speak. You can, in those instances, you can determine a reasonable number of people to speak on the topic. So what I would suggest is at the beginning of a meeting, if you know it's going to be a hot topic that people are going to have their say on, then you ask them to right next, when they check in, let you know what topic they want to discuss. And then maybe at that point, if you can see everybody wants to discuss this particular issue, then you have them appoint somebody to be the spokesperson versus every single person speaking on the issue. So that's one opportunity for them for homeowners to comment right before action or sometime before you take action. What's another opportunity at board meetings? Is there any other opportunity? Yes.
Well, at Parkland Towers, they have a little bit of time, maybe half an hour.
Uh-huh.
This has been various HOAs, a little bit before the meeting starts.
Sure.
Public comment, and then it's.
Sure. So you can certainly, it's not required by Colorado law, but most board meetings, and you should do this, have a homeowner forum session. Maybe before, in the beginning, or maybe after, or some other time, but just a period for homeowners then to speak for a brief time about whatever issues they want to raise. Now, if those issues are pertinent to the action you're taking, they really ought to be taken at that time, right before action. But if it's just a general open session, anybody want to bring anything up, then you certainly can do that as well. Yes.
Can you limit them to like when you're before the action is taken? Can you limit each speaker to like 3 minutes or 1 minute or?
What do you guys think? Can you time them?
Yeah.
You can. You can actually even bring a timer if you think it's going to be an issue and have it ding, and then the person that is presiding though has to abide by that timer and stop them. But yes, you can. And that should be in your policy. One of the things that board members have to have under Colorado law is a policy on how meetings are conducted. And one of the things that you put in that policy is the ground rules for that meeting. So what's a reasonable period of time? Maybe 3 minutes, you put that in there, but it gives the board discretion to increase it or decrease it depending on how many people show up at the meeting. Okay? Yes?
The homeowner forum after a meeting should the meeting be adjourned before or after the forum?
You can have, depending on where the homeowner meeting is, it could be in the beginning or it could be at the end. It's not part of the actual board action or meeting, so it can either be you adjourn and then you have open session, or you can do it in the beginning. So either way.
There are no minutes taken on this open forum?
No, you don't have to. I mean, you can, some boards will actually incorporate it into the agenda itself, and that's okay too. If you incorporate it into the agenda as a standard homeowner forum session is for the first 5 minutes or 10 minutes of the meeting, then that's when you would take minutes. But if you don't incorporate it into the agenda, then it's not part of the meeting. Okay, one last one, then we'll go forward.
If our bylaws don't support the state law necessarily, or let's just say there's a difference.
There's a lot of them out there.
We can just refer to the state law when we're having board meetings.
You can. The problem is, and the question was, if the bylaws are not consistent with state law, can you just refer to state law and enforce state law? The problem with that is some state law, so there's two laws, Kiowa, Colorado Common Interest Ownership Act, and Nonprofit Code, and they both apply to associations. The problem is, depending on the provision that's inconsistent, sometimes the law will say we defer to the provision in your bylaws. Sometimes it'll say the law supersedes it. So if you know, if you've gone through and you know which one supersedes versus which one defers, then I think it'd be okay to say, okay, this trumps, so we're not going to follow this procedure. We are going to follow state law. But there's so many, they're all different. So what I would suggest, if you have bylaws that are probably over 10 years old, I'd say probably 20% of it is now contrary to Colorado law. So have your attorney look at it, because then it'll be a lot easier for you to just revise it and bring it current, and then start enforcing the current law. Okay, executive sessions. What's an executive session?
Talking to your lawyer.
No, not necessarily, but that could be one situation. But what is it?
For personnel matters, it is closed.
Closed sessions. That's what executive session means. It's a closed session. The only categories, I'm going to read them real quick, but they're in Kiowa, the Colorado Common Interest Ownership Act. That's on our website, so if you haven't seen it yourself, you really need to look at this statute. But Kiowa says that you can close board meetings for 6 reasons, and only these 6 reasons. And I see boards go into executive session for all the wrong reasons. So here's where they are. The first one is matters pertaining to employees of the association or the managing agent's contract. So most associations don't have employees. You know, it's very rare. Most associations hire independent contractors. But if you have an employee, you can talk about the employee and whatever the issues are with the employee in closed session. Same with the management contract, or the manager and the management contract. That's the only contract. Do not go into executive session to talk about the attorney's contract, the landscaping contract, the insurance contract. You cannot go into executive session for that, only for the management contract. The second one is consultation with legal counsel. So if your legal counsel is present, you have the right. You don't have to, but you have the right to go into executive session. The third thing is if your attorney actually provides you some opinion and you want to discuss that opinion in executive session, you can do so too. The fourth one is proceedings concerning misconduct. That's criminal misconduct, not covenant enforcement hearings. If somebody has a violation and you are holding a hearing to address that violation, homeowners have the right to know what you're doing to enforce the covenants. You cannot go into executive session for that violation unless it falls under some other category, which we'll talk about. So only criminal misconduct. Any matter, the disclosure of which, matters subject to constitutional, statutory, or judicially imposed requirements protecting proceedings. That's just, there's no list saying what federally is protected or constitutionally protected, but the issues that often come up are disability issues. You're talking certain medical records because somebody's disabled and they want to have a particular modification or something. If you're talking about disability issues, you can, or medical issues, you can go into executive session, but that's hardly ever triggered. Let's see. Okay, here's the catch-all. Any matter, the disclosure of which would constitute an unwarranted invasion of individual privacy. There is nothing that tells you exactly what that is. So let's say a homeowner comes to you because he knows that you are going to have an enforcement hearing about his situation. And he comes to you privately and says, please do not have this in open session because of X, Y, and Z, and gives you the particularities. You as a board can review these on a case-by-case basis and determine, we think that this would invade his privacy or it's a private nature. Then you can determine that on a case-by-case basis. What you can't do is have a blanket rule saying all violation hearings, all collections discussions have to be in executive session, because that's another one. Boards go into executive session to discuss delinquencies. Now, unless the delinquency is with the attorney, and the attorney has given you some status or advice to discuss at the meeting, it's not a subject for executive session. People have the right to know what you're doing to collect assessments. What you would want to do in those situations, though, is you would want to step back and be sort of anonymous about it. I wouldn't name names. I would probably just say we have 10 delinquencies, and here's what we're doing with each one of them. This one's in lawsuit stage. This one is in lien stage. And step back and not name names or addresses or anything like that. Yes?
Should there be minutes in the executive session?
Good question. So, does anybody take minutes in executive session? Has anybody taken minutes before? Okay, a couple of you. A couple of years ago, the law said minutes are minutes. So if you take executive session minutes, then they're open for everybody to inspect, and it kind of defeats the purpose. The law has changed. The law allows you to take minutes now and have work notes and everything on executive session, and that documentation will not be open for inspection. However, 2 things that you have to know before you go into executive session. These are the formal minutes of the meeting. You have to announce the time that you're going into executive session and the category for which you're going into executive session. So, for example, we're going into executive session at 7 o'clock, and we are going to talk about the management contract. So that's your minute the minutes going in. And then, coming out, we're out of executive session at 7:15, and we have decided to hire so-and-so manager. So you can take action in executive session. The only things you can't take action in executive session are adopting a rule or regulation, or amending the articles or the bylaws. Those are the only three things that the statute says you can't do in executive session. But you have to be in there for the right reason in the first place. What I see boards do is they go in for the right reason, and then they start talking about all these other things that have nothing to do with what they went in there for. That's what gets you into trouble. Yes?
What about this discussion of whether or not something constitutes individual privacy reason? If you are talking about it in an open session, then that sort of defeats the purpose of going into...
It is. So I would suggest, I mean, if somebody brings that to you prior to the meeting, that's when you have the opportunity to discuss it. But if they say, I want to, we want to recess, or we want something, then you can have a recess from the meeting, and they can discuss it with you and say, these are the reasons why I don't want you to have it in open session. And then you make your decision then. But it only comes up when the person knows it's going to be an agenda item, and usually they approach the board before they even start the meeting. So it's usually not an issue. So finally, we're only on 5, so I want to really quickly, work session. Work session, I put that in there because a lot of board members get together to work through a particular issue, but they don't take action. So if they don't take action, they argue it's not a meeting, so homeowners aren't entitled to be present. What I say is, let them come to work sessions. What are you hiding? If it's about the fact that the work session is going to be very long, again, you need to preside over that and push back and say, no, you can't keep interrupting, you're out of order, or whatever it is. But work sessions theoretically are not board meetings, so theoretically you're not required to open them to homeowners, but I say to be transparent, go ahead and open them to homeowners and let them observe. Okay? Yes, sir?
On the work sessions, I'm making the assumption that meeting minutes are not required.
If it's not a meeting, you don't have to take any minutes. Now, you can take notes if you want to, but they're not formal meeting minutes because it's not a meeting.
Because we had a situation where our president wanted to use work sessions to discuss items because he didn't want the meeting minutes taken.
Right, and so this is a loophole. This is why a lot of people say, oh, and this is what prompts legislation in the first place, is we're not having a meeting, so we're going to discuss all these things that we don't want to discuss in front of homeowners, and so we're not going to call it a meeting, and then we're protected. I think that goes completely contrary to the spirit of transparency. So even though it is a legal loophole, they're not taking action, I still think it's an issue. It creates the problem that you're trying to eliminate by having these open discussions. One more and then we're going to move forward. That's it.
Valid, say to organize yourself, to organize the agenda for what you're going to have.
Sure. A work session, again, there's no definition of board meeting. So I would say a work session would be not taking action, having directors come together and discuss something and not taking action. So that's certainly possibly a reason to have a working session. What I usually see is if they are amending the documents, for example, or reviewing certain portions of a contract, they want to have that session but not actually take action on the contract. All right, so let's keep going. Number 6, failure to comply with records requests. That's a huge issue against boards today. If you get a records request, and what I mean is a homeowner wants to inspect the records of the association, you better have an inspection of records policy in place. That's one of the 9 policies that the associations were required to adopt several years ago. And it's again in Kiowa. I'm going to read the statute number, so you can take this down if you don't have a policy. But the statute number in Kiowa is 38-33.3-317. 38-33.3-317. If you don't have a policy in place, look at the statute. This tells you 3 lists. The first list is what are the sole records that the association has to keep open for inspection and copying. The second list is what records you have discretion to withhold. And the third list is what records you are required to withhold. The statute covers this, and if you fail to give one of the records in the first list, that's potentially a breach of fiduciary duty by failing to comply with Colorado law in the records request action. I just wanted to name a couple things that sometimes are an issue with records. The first one being, I just got this question today. As a management contract or management company, they asked, am I entitled, or is the homeowner entitled to see my management contract? Yes. That's one of the contracts that's listed under the first list. Same as my contract. If they want to see the attorney's contract, they are entitled. There might be certain things that are, maybe there's employee salaries in the management contract, maybe that might be confidential, but as in general, they're entitled to see the contracts. They're not entitled to see the contracts that are currently current contracts. So they're not entitled to see bids of future contracts, but just the current ones. The other thing I sometimes see is list of homeowners. So what the statute says is you have to provide upon the request a list of all the homeowners and their mailing addresses. So every homeowner gets the right to see a list of all homeowners, mailing addresses, and names. With the board members, it's one step further, and their email addresses, so homeowners can contact them directly. So that's a distinction. The other thing too that sometimes becomes an issue is architectural review requests. What the law used to say is all association records, all financial records are available in all association records. Now it says with respect to ARC records, homeowners are entitled to see the approval or the denial of the particular record. Not all the plans and everything that came up to that, but just the approval or the denial. So these are just a few of the records that I'm pointing out because they come up all the time. You need to look at this statute and you need to get the inspection of records policy in place. The other thing is the procedures for inspection. Previously, the homeowner could ask for anybody's records. I think I already said that. Now, that's changed. You can't ask for anybody else's records, only records that pertain to you, to your own unit. And the other thing you can no longer do is request a proper purpose for inspecting the records. You used to be able to request that. Now you can't do that, so take it out of your form. You can no longer ask for a proper purpose. Finally, what's the other one? Proper purpose, it's gone now. Oh, time frame. 10 days to 30 days, so that you have to either give it to them in 10 days, the records, or have access to them, or within 30 days of the request if it's at the next board meeting or next meeting. So you either have 10 days just to give it to them, or 30 days if there's another meeting that's scheduled in the next 30 days. Did you have a question?
Yeah, you said like the ARC forms, you're allowed to do those, but then you said you're only allowed to ask for your records? What do you mean by your records?
Your own records. So if you have a violation against you, you're entitled to see your file against you. If you have if you want to know what your assessments are, if you're delinquent in any way, you can ask for yourself. You can't ask for your neighbor's records.
Well, but if you're claiming, for example, that you're being treated separate differently.
Yeah, too bad. You cannot ask for it anymore. That's not, because I think the issue was before that people were fishing. And I don't know if that's the case, but you are no longer allowed to ask for anybody else's records.
Huh.
Now, if
So
you go to court,
how would you prove
if you go to court,
yeah.
then you can discover all those records, but no longer through this process.
So before you go to court, you would want to have a case before you spend the money and so forth.
Yeah, you talk to your attorney, and so that's the thing. You can't do it through this process. You can do it in other ways. That was the last one. No, I just lost it. What was the other thing? Oh, that's right. The other person that can ask for it is not just you, but your designated representative can ask for these records too. So that could be a title company, that could be an attorney, that could be your tenant. Anybody you want to designate in writing can ask for those records as well.
Now do board members have access to all the records?
Yep, they should.
Okay. I mean, is there any way that you can restrict a board member?
Yes, I'd say that the question was, should board members have access to the records? Yes, because they need to make informed decisions. Now, there could be a situation where a board member, him or herself, is suing the association or suing another director. Then you could protect the association by making that board member recuse him or herself from discussions and records. The other situation is a board member who is a board member, but asking for records not on behalf of the board member's decision that's coming up, but on their own personal interest. So that could be a gray line, gray area. All right, let's move on. So money message, number 7, no reserve study or reserve fund. First of all, is there a requirement to have a reserve study?
No.
Does anybody know this?
No.
Everybody knows this, yeah, no. There's no Colorado law that requires you to have a reserve study. It is probably in your best interests and financially prudent to have a reserve study done, particularly if you have something to replace in the future. But right now, the law does not require it. What the law requires, and it also doesn't require a reserve fund. So what is it? Well, first of all, for those of you who don't know what this is, what's a reserve study? Can somebody say explain what it is?
Well, it's
Yes.
how much money you have to have in order to replace or the necessary assets.
Right. So there are things that you're going to have to replace in 10 or 20 years. The roof, the fence, whatever it is. You need to know how much money you need to put in your account every year in order to be able to replace that in 10 or 20 years. So a lot of associations will have an expert come out and kind of determine the life value of whatever these assets are and give you a plan. And then you fund that study with your assessments. You're not required to do this, but again, it's better than all of a sudden being faced with a huge special assessment or having to get a loan when you have to replace the roof or whatever the fence is. So it's up to you. But what your governing documents often say, there's no specific statutory law that says you must have a reserve fund, but oftentimes your governing documents say you must have an adequate reserve, but it doesn't say what that means. And the best way to determine what an adequate reserve is to get a reserve study done. You don't have to get an expert to come out and do this. You can do this yourself if you have some expertise on your board. Some management companies will do it as well, but it's a good thing to have. And I would argue that it's your fiduciary responsibility to have it, particularly if you have some large expenditure in the future you're going to have to replace or some asset. Yeah.
I think sometimes insurance companies.
Sometimes they will require it in order to fund or provide you a policy. Possibly, I don't know. Maybe that could be a requirement. But again, the documents often imply that you should have it. What you are required to have per law is a policy. We've been talking about these 9 policies, right? What the law requires you to have is a policy on reserve studies, and it implies in the language. Let me see if I brought that particular one. Yeah. So you have to adopt these 9 policies, and one of them is a reserve study policy. And what the statute says is, to promote responsible governance, associations shall adopt policies, procedures, and rules and regulations concerning, and one of them is, when the association has a reserve study prepared for the portions of the community maintained, whether there is a funding plan for any work recommended by the study, whether there was reserve studies based on a physical analysis and financial analysis. So it says when the association has a study prepared. It's implying that you should, unless you have no common area that you're going to replace in the future, it's implying that you should have a study. It just doesn't absolutely require it upon this statute taking place. So have the policy in place. If you have no common area that you need to replace in the future, your policy could simply say, at this time, it's in the association's best interest not to have a reserve study because we have nothing to replace. Or if you don't have the money to get one done immediately, you can say, within a reasonable period of time, we are going to have a reserve study done when the board of directors determines it's in the best interest of the association. But it is a good thing to do. It really is. Yeah.
So we're pre-Kiowa.
Uh-huh.
And our policy says a reserve study will be done every 3 years. It's required.
So your policy is first of all, let's take 2 statements. One statement was she said she's a pre-Kiowa association. What is that? What does that mean? Pre-Kiowa. Can anybody tell me? Before 19-something, right? 1990. So Kiowa is a statute that governs all associations. Colorado Common Interest Ownership Act, Kiowa. If you're a pre-Kiowa association, that means you were created before July 1st, 1992, which means only some of Kiowa is applicable to you. If you're created July 1st, 1992 forward, all of Kiowa is applicable to you. So know that distinction, particularly if you're a pre-Kiowa, you're only subject to some of the statute. But you said your policy requires you to have it done every 3 years, or you review it, right? That's driven by you, your policy. So if your bylaws require that, not your policy, but your bylaws, your governing your declaration, you have to follow it. Every 3 years, you have to review that study to make sure it still fits, still works. If it's not in your declaration and the board adopted the policy, you can change that anytime. You can make it every 5 years. You can make it every year. So it's driven by the board if it's in the policy. Okay, let's move on. Ineffective collection process. So, sorry. Failure to review contracts. I would say what I hate seeing, and I see this all the time, is boards will enter into these $500,000 projects and not have their attorney look at their contract, and the contract's 2 pages long. That's just amounts to disaster. It only takes one thing wrong, and if you don't have the remedies and the protections in the contracts, then you are not going to be protected. And I'm not saying that contractors are going to be drafting things contrary to the association. It's just that the contractors have their own interests. So they're going to draft the contracts to serve their own interests. Did you have a question?
One time I did a contract to sell a big World War II warbird plane.
Okay.
The job I was in. And the person I was selling it to really got friendly with the secretary and told the secretary to add one teeny little word to the contract when she finished it.
What was that
and
teeny
the
word?
Was variable.
Variable?
Variable.
Okay.
Which meant that we sold a plane that was not able to fly. But he got the secretary to put that word in there, which meant
it had to
be able to fly.
Oh, wow.
It cost us $100,000
to bring it up to,
because the secretary got suckered in by this guy and put that word in there, and we didn't realize she did that, so the attorney never saw that word in there. Sure. So well,
we've had a situation. I mean, that's exactly right. The devil is in the details. One little word can change things. We had a situation where we reviewed a contract and then we provided our recommendations, but then the board, a couple of board members, changed a few things without letting us review it, and again, it caused problems. The devil's in the details. There's so many things. I'd say anything over $7,500, I'd probably have the contract, an attorney review it. I know that seems like a smaller amount, but $7,500 could be a huge amount for a lot of associations, and you want to make sure that you have these standard provisions. We have an article on our website that's, I believe, called Deal Breakers or something. So these are the things that you really want to review in construction contracts and other kinds of contracts. But the thing that I often see is, number one, automatic renewals. If you have a contract that's for service and it automatically renews if you don't terminate it within a specific time frame, all of a sudden you're stuck for the next 3 years. And courts are going to say, it's very clear. You have to, you can't get out of that contract for another 3 years. You might be able to argue it, but you want to get rid of the need to have to argue it, and either get rid of the automatic renewal or be comfortable with it and know the termination provisions that come with it. Another one is no termination for the association. Same thing. There could be a way for the contractor to terminate the contract based on some kind of breach of the association, but no similar way for the association to terminate the contract because of breach. All of a sudden the association has to give 3 months for the contractor to cure before you can terminate it. So termination provisions are a big one too. Attorney's fees. I'm not trying to line my pockets here, but you want an attorney's fees provision in your contract, because if you don't, then sometimes it costs more to hire the attorney to get the job done for the judge then to say, oh, you don't get your attorney's fees for this. You only get this $10,000 that you were asking for, but not the $15,000 that your attorney just charged you. So you want an attorney's fees provision saying, if we prevail in court, we get our attorney's fees as well as the judgment. And the last one I think you should have is something called indemnification. What that means is if the if the association is sued because of some kind of negligent or willful act by the contractor, then the contractor has to indemnify or defend the association out of its expenses. So you're not brought into the lawsuit without having somebody else who was really at fault have to pay for it. That's what you want. You want them to be able to defend you if you're sued because of their actions. So those are just 4 things that I see are deal breakers, but you definitely want to address them in your contracts. We can give a class just on contracts, but get on our website and look at the deal breaker article as well. Okay, ineffective collections process. So again, I'm talking about the policies that you have to have in place. And first of all, courts, they do look at whether or not you have adopted your 9 policies. And there's 2 policies out of those 9 policies that are more important than the rest. One of them is covenant enforcement. If you're going to enforce against somebody and levy a fine, you have to have an enforcement policy in place that establishes and clarifies all the due process that the homeowner gets before you fine them. But the other main one is collections. You have to have a collection policy in place, and it has to be consistent with the law that changed 3 years ago now. HB 12, I can't remember the House bill number now, but collections was essentially overhauled. You might have these specific provisions in your covenants that already address how you're supposed to collect assessments, but you have to have this policy in place that adds additional language. If you go to court and you have a clear case against a homeowner who has not paid his or her assessments, but you don't have this policy in place, or you don't have the right language in the policy, you're going to lose in court. The statute is very clear. You have to have this. So one of the things that is new, I'm just going to tell you, because most governing documents in the collections section of the governing documents just essentially say you have the right to have maybe a reasonable late fee, or liens for failure to pay, or maybe interest is accruing. So these general statements. But the collection policy goes a step further. It tells you that you have to state the date on which the assessments have to be paid. So your policy has to say for your regular assessments are due on the first day of every month, for example. So it's very specific on the due date. The other thing is, if you are going to levy a late fee, you have to state the late fee amount. You can't just say a reasonable late fee. You have to state the late fee amount. I'm just naming a couple of things that would be in there. The big one is, now what's new is before you turn over any collection account to the attorney or the collection agency, you have to offer a payment plan to the debtor. So you have to give them a reasonable payment plan, at least 6 months. So you have to, so for example, if they have a principal balance of maybe $1,000, you have to give them at least 6 months to pay off that amount, plus keep current on the regular assessments that come into play during that period. So that's another thing. The other thing too is foreclosure. You can no longer go into foreclosures without having a formal vote on every single proposed foreclosure. Some associations used to say everything over $2,000, go ahead and move forward with the foreclosure. You can't do that anymore. You have to vote on every single proposed foreclosure. Do you have a question?
The payment plan, you just have to offer it once.
That's
right?
correct. That's a good
It's
distinction.
not like a yearly thing. You always have to offer them. They keep getting $100 behind. Or...
Right, right. The statute says that you have to do it once under this new law. And if they are delinquent again, let's say they come current, and the next year they're delinquent again, you no longer have to offer that payment plan. So just once. A lot of associations will offer it every single time. They don't want to monitor which ones that they've offered it to. And so that's up to you, but you are not required to do it forever for this particular repeat debtor. Okay? So those are just a couple of things that you know, you should know. You should have the collection policy in place, and you should make sure that it is consistent with Colorado law as changed a couple of years ago. I put amendment in there too, because sometimes the governing documents themselves they have limitations. If you have a covenant that says you can't charge more than $5 per month for a late fee, that's not incentive to anybody, I don't think, to pay. So you want to take care of some of those limitations in your covenants themselves. Any question on collections before we move forward? Yes, sir.
Is there a statutory limit on the amount of late fee?
Not a statutory one, no. You could, your documents, sometimes the governing documents themselves have statutory amounts, and there could be an argument of usury. So if the late fees and the interest and the other administrative fees exceed, I believe, 45%, I'm not sure of the balance, the principal, then there could be an argument that it's usurious what you're
So there's
charging.
nothing like you can only charge, $50 fee or $100 or whatever.
Nope, all the statute says is reasonable. So you shouldn't have $100 late fee if your monthly assessments are $35. Okay, which I've seen sometimes, which is not good. All right, yes.
Oh, our homeowners association had to let somebody off the hook that owed for years their annual dues, and they got off because we had changed management companies
Oh,
like 3 times in
and
5
the
or 6
records were
years.
lost.
So the records were
See,
not consistent.
That's problematic. It's more of a kind of lesson learned moving forward to make sure that you have the records. I know it's difficult when you transition from management company to management company. Sometimes the records get lost, but that's the first thing that the attorney is going to look at for the debtor is, do you have the backup? Do you have the documentation? And if you don't, then it's going to be a problem. We're going to say probably write it off, and moving forward, keep better records.
Yeah.
We have one person who pays late a lot.
Okay.
Like doesn't pay, then pays.
Yeah.
Doesn't pay, then pays. Is there any provision to what to do with that kind of person? Because they pay up, but
Well,
it's sort of
does anybody know what acceleration is? Have you heard of that? Okay, you're nodding yes. So for repeat debtors, you might, if you have the authority in your governing documents to accelerate, then you might want to use that. And what accelerate means is that you can call the entire year's worth of assessments due. So all you have to do is collect one judgment and have one judgment for the entire year, and you don't have to go after them throughout the entire year for the repeat debtor, every time they go delinquent. So you only have to pay your attorneys one time to get that judgment. So let's say in January the debtor is late, and this is a repeat debtor that does it all the time, and the assessments are $100 a month. You can ask for $1,200 in your judgment, and then you don't have to go after them again for the entire year. So that's one way you can do it. That's really pretty much the only way that I could see for repeat debtors is to try to get acceleration. Okay, next one. Money messes. We're still in money messes. No due diligence with big money decisions. We talked about this already in the beginning of the class, that you want to make prudent decisions, particularly with money issues. You definitely want to document your bids, for example. Document that you had bids, different bids. Don't just go with the same company all the time. Don't just go with somebody who doesn't really have a history or background or good, a mom and pop store that just fly by night and just came into place. You don't want to go after that, use that contract. But you want to make sure that you document your decision. Now, the first bullet point about governing document requirements, this is key. I see a lot of associations violate these because all governing documents are different. For example, some governing documents will say you cannot levy a special assessment for an expense unless you get homeowner approval. Not all of them say that, but some of them do. Another one that some of the older documents will say is you cannot spend more than a particular amount per year or per project without homeowner approval. That's another issue. Another might say for this particular type of contract, you have to go to the homeowners for approval. That one I sometimes see for any capital improvements, which are new modifications versus maintenance, repair, and replacement. So it's really nuanced in every single governing document. So you have to be careful. If you're going to spend a lot of money on a particular project or throughout the year, you need to make sure that you're doing it correctly and per the specific requirements of the governing documents. Thorough investigation just means of the potential vendors as well as the governing documents themselves. And then what's really key to try to eliminate or minimize any issues with homeowners who are saying, what are you spending my money on? Why are you spending this big amount? Is over communication before, during, and after the project. Before we're about to go into this project, maybe the board has every right to do it on its own, but you still want to push it out there for feedback. You don't want to replace the pool and put in a parking lot, even if you might have authority to do that without asking the homeowners. That's going to be a big political nightmare. So just because you have the right to do it doesn't mean you should do it without input from the homeowners. And then during the project itself, communicate over and over, you know, this particular building is going to be painted this time. You're going to have to be outside of your building for this project. And just constantly give them that information so they're in the know. And then finally afterwards, when the project is done, showcase it. Highlight it. Showcase your successes. These are things that you need to do whenever you spend a lot of money to show that you're spending their money wisely. Okay?
Any requirement to get multiple bids on a project?
Is there any requirement?
Yeah.
There's no state law that requires you to do that. But again, we're talking about financial prudence, so you probably want to do that. Okay?
Because our HOA management company guy, one of our people said, you know, our landscaper is recommending we spend $80,000 in rock. Should we get a second bid on that? And the management guy came back and said, oh no, it's much better just to deal with the guy you're used to.
Well, you know what I mean, on the one hand, if a contractor has a demonstrated history of doing a really good job, I can see how that might be just fine. But I also think that the perception is that, you know, I mean, you're just going with the flow and you're not really making an informed decision. So it's good to have the bids open. I mean, not open, but done.
See, my problem is, what's the value of the project being done? Are we getting a good deal?
Right.
You know, it's kind of like, what's the price of a, 1932 Studebaker? You know what I mean?
Right.
I don't have a clue what that should cost, so
right.
the guy could be gouging and I wouldn't know it.
Yeah. Well, it could. I guess it depends on the particular project. So.
It won't hurt to have more.
It wouldn't hurt to have more, right? Okay, number 11. This is probably fair housing violations. Has everybody here heard of the Fair Housing Act? Because if you haven't, okay, has everybody here heard about the emotional support pig that was allowed on the plane? Or the emotional support miniature horse that was allowed? Okay, so that has to do with the Fair Housing Act, okay? So fair housing violations are huge, and I'll tell you right now, they could amount to huge penalties for the association, lots of monetary penalties. Plus, you might have to go through some training if you don't know what this means, but if you don't comply. And I'm going to just talk about two scenarios. The Fair Housing Act is essentially an act, a federal act, that's also in Colorado. They have their own we have our own statute, that prohibits an association from discriminating against certain protected categories. The two categories that always come up in the HOA context is discrimination against, and I'm sorry, it should say this right there, disabled. It shouldn't say discrimination, it should say disabled. So discrimination against people with disabilities. That's the first one, so if you could write that in instead of the discrimination. And the second one is families with children. Familial status is families with children. I'll talk about that one first. You can't prohibit or discriminate against families with children, and what has arisen is associations may adopt rules or regulations that treat families with children differently. And the one that usually comes up is the swimming pool violation, where it says no kids are allowed in the pool. No kids are allowed, and usually it's because they don't want all the rowdy behavior going on, or it says no kids without an adult, something like that. Or nobody under 18 can be present at the pool without an adult or without some guardian. So that has been deemed as discriminatory against families with children, because others that don't have children, they can access the pool whenever they want. What the problem is, the reason why a lot of associations don't want children there without an adult is because of safety reasons, right? Right. So that is the exception. But if you say, so the exception is, if it's for safety reasons, okay, that's one thing. But if you say no one under 18, how safe, I mean, a 17-year-old or a 16-year-old, is it really a safety violation or a safety issue if they're at the pool without their mom or dad? No, it's usually they don't want the teenagers partying. So if it's a safety violation, The CCRD, which is the Colorado Civil Rights Commission, or Division, has said 12 or 14, anyone under 12 or 14, I would just say anyone under 14. That has been deemed as an appropriate age, minimum. But if you say 15 or anyone under 17, if they can demonstrate that they can swim and they can swim without an adult present, then I don't think that that's a safety issue. Same with a kid that's under 14. So even if you say no kids under 14 without a guardian, and you have a kid that is a champion swimmer, I think that you would be able to give that kid an exception, because again, it's not a safety issue. So that's just one example. There's others with respect to familial status, but I wanted to talk about that one. The second one, the one that's so popular right now, it's all over TV and all that, is the disability one. If a person is disabled and they want a reasonable accommodation to their disability, they don't want you to enforce a particular regulation against them, you are required not to enforce that regulation against them. What usually comes up is pets. If you have a restriction that says no pets, and an easy one is a blind person needs a seeing eye dog, you must allow them that pet, because they need the seeing eye dog in order to have an equal use and enjoyment of the community. What's not so hard, or what's not so easy, is if the disability is not obvious. So let's say you have somebody who might have some kind of mental disability, and maybe they have PTSD, maybe they have severe anxiety, maybe they have severe depression, or whatever it is, and they need the pet. You can't tell by looking at them. What you are allowed to do in those cases is you can request some kind of documentation that, number one, they're disabled, and number two, they need the accommodation for that disability. And the type of documentation, it doesn't have to be a doctor, it has to be somebody that can give that information, someone that has the knowledge of your disability. It could be a social worker, it could be some other medical profession, it doesn't have to be a doctor. So the only thing I want to talk about tonight, again, this could be a whole class, is they have to be disabled. If it's an obvious disability, you cannot ask them for any other information. If it's not an obvious disability, you can ask them to provide some documentation showing that they're disabled and they need that accommodation. So, so that's the other big one, is people with disabilities. There's two types, real quick. We have, reasonable accommodation. That's the one I just said. You don't enforce a particular rule against that particular disabled person. The other one is reasonable modification. If a disabled person wants to make some kind of modification that allows them equal use and enjoyment of the community, you are required to allow that, even though you might not normally allow it to somebody who's not disabled. Yes?
We have several garage ramps.
Uh-huh. Okay.
And we're elderly.
Okay. So, I mean, the ramp, excuse me, the ramp is a perfect example. An ARC might not normally allow a ramp to be installed on the exterior of a building, right? Because it might not be in harmony with the rest of the building. But if a disabled person needs the ramp to access their unit, they're required to allow them to have it. The difference is with the reasonable modification, it's at the disabled person's cost to install the modification, not the association's. Okay. So again, this is something that we can go into a ton of different scenarios. There's this great, there's a statement online called, the Department of Justice and HUD got together and put together a joint statement of what it means to request and what you have to do in response to reasonable accommodation requests and reasonable modification requests. Those are both on our website if you need more information on that.
Is this Colorado law tougher than the Fed law in Colorado?
Yes.
It is. Okay.
Well, not tougher, it's just that it has more categories for discrimination.
Oh, it is. Okay.
Yeah. Okay, we have 15 minutes, so we're moving right along. Annual meeting issues. So annual meeting issues, I think the one thing that comes up quite a bit is, anybody, first of all, tell me what quorum is. I'm always gonna throw this to you. What does that mean? What's quorum?
A majority.
Huh?
A majority.
Well, that could be a type of quorum, but what does quorum mean?
Minimum required to act.
How many people have to be present to hold a meeting, right? To take action at a meeting? How many have to be present in person or by proxy to hold a meeting? A lot of associations have a pretty high quorum requirement, maybe 50%. In a community of 100, that you have to have 50 people present in person or by proxy. That's pretty high. What Colorado defaults at, if you don't have a particular quorum provision, is 20%. But most bylaws are very clear about what the quorum is. What you have to remember, though, is quorum is, there's usually just one quorum for any meeting of the owners, but every once in a while there's a higher quorum for particular types of actions, such as levying a special assessment. It might actually say, for all other meetings it's 20%, but for special assessments, it's 60%. So be clear and make sure you look at that. Now, if you don't have quorum at the annual meeting, what happens? What do you guys do? Do you guys have difficulty getting quorum?
Yeah.
So if you do continuously, then I would recommend amending to reduce that quorum. Of course, that means you have to go around and get homeowners to approve it, but, so it's a vicious circle, but you should at least try. But if you don't get quorum, can you take any action? No, you can't take any action. You can't elect directors. There's an exception for budget ratification, which we won't go into now, but election of directors, you cannot elect any directors. So what happens to the directors whose terms have expired if you have no quorum? What do? Do they?
Nothing.
Nothing? Do they continue to serve?
They continue, I think.
It depends on your bylaws, I think.
So, somebody said they continue or they stay on. That's correct. If for whatever reason you don't meet quorum or you don't elect directors that year, and the directors' terms have expired, those directors' terms whose terms have naturally expired continue to serve until the next election. So that could either be next year, if you don't have an election for another year, or you could set a special meeting to try to get quorum, so it could be next month, or those directors decide they don't want to serve anymore, so they resign. Now, if a director, let's say you have a 5-director board, and 2 of them resign and 3 stay on, what happens then to those vacant positions? What can you do? Can you have to hold another election?
The board can appoint.
The board can appoint them. Sometimes the governing documents will require homeowners to appoint them, but overwhelmingly, both the law and the bylaws state that the board can appoint vacancies. It's only if the position is vacant, so the person has to resign. If they don't resign, they continue serving until the next election. But all other actions you can't take. I mean, you just have to either try to get quorum again in another meeting, or don't take action. Don't approve that special assessment. Hold another special meeting in the future, but you can't do it at the annual meeting. Okay? So proxies and ballots, another thing that I see as an issue is sometimes, so proxies are proxies, they're not ballots. They're not supposed to be used to vote on the issue. You're supposed to sign the proxy if you can't attend the meeting, and then you specify somebody who's going to be at that meeting. And if that person is not at the meeting, then that proxy can't be used. The other way you can do it is the proxy goes to, and then let's say there's a blank there, and if you don't write a name in, then it could default to a particular person, such as the board president or whomever. If it does that, and it defaults to the person, and that person is not at the meeting, you can't use the proxy. Whoever it is that it defaults to, whether if it's blank or if you specify somebody, has to be at the meeting in order for that proxy to be counted. Now, once you come to the meeting with these proxies, you're supposed to exchange those proxies for ballots. You don't hold on to the proxy. The proxy gets exchanged for ballots, and the ballots are what you vote. And I see this happen all the time where people just keep the proxies and they don't exchange for ballots. I mean, I think that's an issue because a proxy is not a voting document. It's just an authorization to vote on your behalf. Now, a proxy can either be general or directed. If it's general, it means the homeowner can, or whoever is the proxy holder, can vote however they want on your decision. If it's directed, then you are supposed to vote as directed on the proxy, yes or no, or whatever. The problem is, you don't really know whether they're gonna vote the way you wanted them or not, so that's kind of a trust issue. But anyway, so just realize that proxies and ballots are different documents, yeah.
Can you specify on a proxy it's only to establish quorum?
You can. Now, election procedures, the only thing I wanted to raise was with elections, you can no longer have, if you have a contested election, which is more people are running than positions open, so let's say there's 3 positions open for the board and 5 people are running, which probably never, ever happens. But if you have a contested election, you have to hold the election by secret ballot. So no identifying marks on that ballot. It can't say who's voting, for example. It can't say owner whatever, owner Smith voted this way. So just bring back blank ballots just in case to your annual meeting, in case it becomes a contested election. Because sometimes it's not in the beginning of the meeting and then it becomes one near the election time. Yes?
I'm sorry, I missed what you said as far as converting proxies to ballots.
Yes, you're supposed to, when you check in and you have, let's say you hold 5 proxies, you're supposed to submit those to whoever's checking you in it to exchange for ballots to vote on whatever the issue is. So let's say you have 5 proxies plus your own, so you have 6 votes. They should give you a ballot that says 6 on it, so it's counted 6 times. Yes?
What about write-ins?
You can certainly have write-ins, and so the problem with directed proxies is they're not going to know who's going to be written in at the time of the annual meeting, so it kind of limits their choices. But you can certainly write in candidates as well. Yes?
What if your community votes to expand the board from 3 to 5, and then you have 2 more vacancies? How do you fill those?
Well, if your board votes to expand them to 5, and it votes, it can either appoint somebody in at that point as a board meeting decision, and then at the next election, elect those positions in. Most of the time when boards increase the number of directors, they do it in conjunction with the annual meeting so that it can be elected in rather than the board doing it themselves. So it'll depend, when they're doing it.
If the community votes to expand it to 5, includes those?
If the community votes to expand it to 5 and it's at the meeting, then at that point they can elect in the new directors.
Okay, thanks.
Okay, let's move on. Miscellaneous. Number 13, satellite dishes. What you should know about satellite dishes is that there is a federal regulation, the over-the-air reception device rule, which I'd say probably 90% of your governing documents are probably contrary to this regulation, which does not allow, it prohibits the association from asking homeowners to get approval before installing satellite dishes on property that the owner owns or on property that the owner has the exclusive use over. So with condos and condos, for example, the exclusive use area is usually the balconies, right? Or some maybe courtyard. You can no longer ask for approval because what it's seen, requiring prior approval, is an unreasonable delay on the owner's allowance or owner's right to install a satellite dish. What you can do is you can require the homeowner to follow your preferences. You can adopt location preferences and installation preferences and essentially adopt satellite rules and regulations that say if you're going to install a satellite dish, then the first location preference is here. The second is here, and you go through this list. And as long as those location preferences allow the homeowner to get reception, good reception, not the best reception, but reception, then they are valid. Now, pay attention though to what I said about within the lot lines or in the exclusive use area of the homeowner. For anybody here with a condo, in a condo association? So, the roof is not an exclusive use area, so you can still prohibit satellite dishes from being installed on the roof. Or you can require homeowners to get permission before they install on the roof because it doesn't fall within the protection. Same thing as maybe the sides of the building. They're not the exclusive use. It's usually balconies and terraces that become an issue. Yeah.
But if you're not a condo, if you're fee simple,
If you're a townhome or a patio home or single-family home, then it's within your lot lines. So you don't have the same kind of regulation authority that you do as in a condo. So I'm just generally going over that. There is a really good article on our website that's just satellite dish FAQs. Because this gentleman brought up the difference between townhomes and condos. That's really key. Anybody in a condo versus a townhome? So that's really key, because condos, you don't own the building. You own the airspace within the building, within your unit. Townhomes, you own the building. So you have more protection.
Some townhomes are condos, right?
Some townhomes are condos. So you need to know whether your house is a townhome or a condo. First, you got to figure that out. But if it's a townhome, you have more regulation authority over your own unit, and the association has less, even though the association maintains the exterior. Okay, I'm going to keep going.
By the way, this thing applies to TV antennas too.
Antennas and satellite dishes, if you get on our website, what I'm going over tonight are just glimpses, real brief kind of discussions of each of these items. But it can be pretty complex when it comes to satellite dishes, antennas, what kind of regulation authority you have and don't have. Water intrusion. For those of you who are in condo associations, I'm just going to bring, and townhomes that are stacked, I'm going to bring up the big myth that everybody thinks is true, which is the source of the water is going to dictate who's responsible for the damage caused by the water. That is a myth. Just because it might come from the roof doesn't mean that, which is maintained by the association, doesn't mean that the association is also responsible for the damage to the interior of the unit. Do not assume that. It might become that after you go through the analysis. But what most documents say is owner is responsible for the damage on the interior or for repairing the interior. Association is responsible for repairing the exterior. What shifts this, what could hold the association responsible for the interior, is if the association was negligent in failing to maintain the exterior. And that negligence then caused the water to intrude and damage the interior. But if you don't have that, so for example, there's water coming in and there's mold and the homeowner never tells the association that there's anything wrong with the roof, but it's been going on for some time, and then the association does get notified and takes timely action after the notification, there's no responsible for the interior damage. Or a pipe. A pipe is inside the wall. How is the association going to know that that pipe needs to be repaired? So again, it's the timeliness and the notice of the need for repair and failure to timely repair. The second way that responsibility could be shifted to the association is through insurance. Because even if that negligence has no factor in that, if the association is required to insure the interior of the unit, which most associations are required to do for condos, even though they have no maintenance responsibility, they still have an insurance responsibility, and there's some kind of insurable loss that's triggered, you might have to pay for the interior damage through your insurance proceeds that are available under your policy, depending on what policy you have. That's, again, a very brief statement, but just don't make the assumption that the association is always going to be responsible for interior damage. That's just not the case. Yes?
You're talking a lot about water damage within units.
Yes.
Like in our neighborhood, we have irrigation, and the irrigation system is owned by the homeowner. So
okay.
What happens if, let's say, you've got a homeowner who is kind of far down, they're in a low spot in the neighborhood, and the irrigation is flooding their basement?
So who's responsible for the slope? Because that's key. If you need to know, sometimes it's the HOA, sometimes it's the owner. If the HOA is responsible for the slope, and the association is then put on notice that, hey, water keeps going down this slope and going and intruding into the basement, and they don't take reasonable action to address it, so that's key too. What's the action that they're supposed to take that's reasonable? And it continues to flood the basement, then I think there's an issue. Then I think the association might be responsible for repairing the basement. But you have to know who's responsible for addressing the issue. It's not necessarily the drainage system or the common area irrigation system, it might be the slope. So it depends. I know that people hate that answer, but it really does depend on the facts.
Another thing is like, sewer lines, so like
Yeah.
during rainy season, I mean, you've got like overflow in the ditches, I mean, your yards get absolutely soaked. So what if that damages, quote unquote, somebody's sewer line? and
Sure,
they have to
sure.
pay to replace
I
that?
think it's the same thing, which is once the association knows that a particular component under their responsibility is causing damage, then they have a responsibility to take care of that problem. Now, that works the other way around too, which is once a homeowner knows that there's a particular issue, maybe it's their slope, you know, they have a responsibility to take action. Now, if they take action that's reasonable, then I'd say they've done what they're supposed to do. If they ignore it, or if they negligently address it, then again, there's probably exposure to liability. So it'll depend. Did you have something?
Yeah, on that same subject, what if it isn't a problem?
Uh-huh.
The sewer line is exposed because of the irrigation water, but there is no problem, and then let the board know that it,
Needs to be repaired?
well,
Or needs to be
what
addressed?
are we gonna do? Yeah,
So this is what courts are gonna look at. Boards have a number of things and projects that they have to address. So it'll depend on the urgency of the project and the other circumstances surrounding the association. So for example, you say there's a problem with the irrigation system or whatever it is, and the board says, thanks for letting me know, and we're gonna budget for that repair to happen next year. That could be timely, that might not be timely. You know, it depends on how urgent the issue is. Versus, this stairwell is falling apart. People are gonna get hurt on this. And then you tell the board, and they fail to take action immediately to address the safety hazard, then there's liability. So it really will depend on what they do, whether they take action, and the timeliness of the action considering the problem. So I know I missed one last, I'm gonna keep answering questions, but I want to respect everybody's time really quickly. Dysfunctional boards, number 15. I don't know what to say about that, except there's a lot of dysfunctional boards out there. We actually have a class on dysfunctional boards. And what I mean by that is there's no trust, decisions never get made on a regular basis, things get tabled all the time, and avoidance of accountability, nobody calling the other person on what they're doing wrong. So these things, they're going to cause bigger problems if you don't address them right away. We have tons of material on our website to address that as well. And that is the end of tonight. Again, I'm going to open it up for questions for anybody who wants to stay, but I wanted to respect Thomas's time and anybody else. Thank you for coming.